Hey, what's up, everybody? This is Elite After back with a brand new video. Today, I want to break down the Section 609, give you a little bit of an overview, legal due process, and some of the recommended strategies. This has been up and coming. This topic is very crucial for a lot of individuals out there, not for the reasons as to just for the sake of being on YouTube and giving you content, but at the same time, you guys exploring your own means and strategies, trying to go out there, trying to execute a plan where in fact you don't know whether or not the outcome is going to be positive. Just because you saw a couple of good reviews on the internet and a lot of people talking about it, these are individuals who are on the forefront of it. Of course, these are customers. Some of them are companies, but end result is it doesn't necessarily mean that they are legal professionals. It doesn't necessarily mean that they are behind the scenes with policy making, with execution, with the fact of enforcement, working with the government agencies, working with the consumer reporting agencies on the standards of compliance, regulatory rules and guidelines, as well as additional information that's necessary for companies who are actually reporting information on the reports. That you're 100% aware of what's going on. Okay, so breaking down the FCRA Section 609, essentially that's a rule of the Fair Credit Reporting Act. A lot of people utilize this strategy specifically, asking them to comply, with the FCRA. They send out these templates, and they charge you some money to download their templates or whatever it is, and essentially they ask you to use that system to get the negative items from your credit report removed. So let's begin with a small disclosure. The reason I give this now is because the information we're going to share with you will constitute some legal information. I just don't want you guys to think that I'm an attorney. So again, just going to read this out, and I want you guys to pay attention to this, okay? So based on this disclosure, do not take this as legal advice. I'm not an attorney, nor do I recommend any legal strategies, but for any advice, I strongly recommend that you contact your own attorney, legal counsel, and verify the information shared. Of course, the ideas on this presentation are for information purposes, and you can't take them as legal advice. If you do that, you're mistaking it, and basically, if anything happens based on the actions you take past this point, I cannot be held liable for the injuries, okay? So by listening to this presentation, you agree and, of course, confirm and accept the terms. So let's begin by talking about justice. What is justice? A lot of people, out there say, well, look, the Section 609, FCRA Section 609, that's the only way, it's the right way. It works, and of course, it's the only way to get credit reports to get corrected or fixed by removing these negatives. Now, the goal of the justice system, particularly in the credit reporting side, is to create a landscape where the system can be fair to both the consumer, the data furnisher, and of course, the credit reporting agencies. Okay, so it's not a question of who's right or who's wrong. Okay, that doesn't work. That's not how it works. It's a question of you have to prove that there was an intent to harm, and there was an intent to not follow the rules and regulations. Particularly with the FCRA, the state rules, the federal rules. And of course, they have to demonstrate through proof, possibly yourself, or clear documentation with your attorney, that they were willing to cause injury and harm to you on your reports. So a lot of people use the legalese of letters, particularly Section 609 and all the other ones, in an attempt to enforce FCRA rules and regulations, and being challenging them. But if you're not an attorney, right, it's gonna be tough. It's going to be tough, and what would be the procedure based on correspondence that you receive, right? So simply put, if you end up in court, how can you handle yourself, or how will you handle it? Will you hire a professional attorney, which cost, you're going to spend thousands of dollars possibly, because it can go on, and they can play games with you and bury you in paperwork? Or are you going to represent yourself, which we call is pro se litigant? When you represent yourself, it's called pro se. You go out there. How are you going to handle the situation when your questions or the interrogatories, come back and challenge you based on certain questions that you can't simply answer because, again, for a fact that you won't comply with the rules and regulations. So let me go into why I created this presentation for you guys. It's because, number one, I want to provide clarity for those looking for information that can be verified, authenticated, and confirmed with many, many sources all the time. Whatever details I give you or information I share with you, it's 100% verifiable. Also, I want to inform you of what is really out there, right? I don't want you guys to get misinformed, so you got to protect yourself from that. And of course, people who are just simply looking to reach your pockets, okay? And then, of course, I want you to plan the proper way so you can take the appropriate control of the situation. So here's the breakdown, a very basic breakdown of the Section 609. So first of all, when you ask the credit reporting agency, you have to comply with the Section 609. Basically, they're supposed to provide you with information on who is reporting, what type of account or creditor, who they are, and why they're reporting. Most of that information is literally found in your credit report. Sometimes Credit Check Total doesn't have all the info, but when you get an original credit report from the credit reporting agencies, namely Experian, TransUnion, and Equifax, they contain all those details. And some of the information on creditors should include technically phone numbers, address, their name of the business or trade, and what kind of categories they have, the balance limit terms, etc. Some of these information, like balance terms, all these type of little things can be misplaced, but identifying information should be there. So identifying information is essentially phone number, address, the business name. Most of the time, it's almost accurate. Some of the creditors or collection agencies don't have, like for example, you send them a letter and it comes back rejected or not delivered. You can ask for an updated information. Technically, you have Google search, you can find them. If it's not there, whatever it is. But most of the times, it is information that you can actually get on your reports. Also, they're supposed to give you a disclosure that you're able to ask for verification of information based on how it's being reported. And they have to give you your individual rights under the FCRA as well as the federal authorities who actually enforce them. So that's basically the breakdown of Section 609. And that's the real breakdown, okay? So there are some common misconceptions with the Section 609. A lot of people use this to basically scare you into making you believe that that's the only way, right? So they say, look, you got to handwrite your letter. So let's say you spend like $15 to $20 on some template, and they're going to say, this is how you do it. They give you all sorts of spills and stories, and they say, handwrite your letters. And then you got send it notarized, okay? Well, yeah, of course, you can do that. They also tell you that this is a legal loophole. That's actually a scam, right? Whenever somebody says it's a legal loophole, there's no such thing. The legal system in itself is made for justice, like I said, for complying with rules and regulations to make it equitable, easy for both FCRA data furnishers, yourself to work with each other so you can borrow. If it wasn't solid enough, then every time you try to apply for credit, you'll have like 10,000 verification pieces to go through, right? They try to streamline the process. And particularly, in Section 609, these are rules of the government. There's no loophole around it. So just keep that in mind. And some people say get results in 30 to 45 days. And a lot of people say that, just because they want you to fall for the trick and be impulsive when making decisions on buying those templates. Just be careful with that. They say that it's the best method to remove negative items from your report. I don't know about that, but again, that's a misconception. I'm not saying that, some of these statements, I don't necessarily agree with them. And let's just put it in my opinion, professional opinion. Of course, I'm not giving you based on my personal experience. I'm saying professionally. A lot of people say it works for everyone. Well, not necessarily, right? It doesn't always work for everyone. So let's go over a scenario, like a story. And I'm playing this out so you can get the emphasis of why Section 609 can go horribly wrong for you if you don't execute it the right way. So day one, you're in court. You're asked to specify what your concerns are against the credit reporting agencies. And you say to the judge, look, I have a Section 609. It's certified. I saw that they received it. And then the judge will ask you, like, on the opposing counsel, actually not yourself, but the other party. Let's say if it's Equifax, they're going to ask Equifax, why the items came back verified about the letter, if they saw it. Of course, the opposite party is going to say, well, the information is verified based on the certified compliance of the AUD, which is the Universal Data Form. I talked about this in a couple of my other videos. Based on the Credit Reporting Settlement Agreement in 2015, they have a little checkbox. They can say it's certifiably compliant, and that basically justifies accuracy and verification, okay? And basically at that rate, what happens now is the judge will ask you, okay, are you challenging this because the item's not yours? Is the information yours? If the judge doesn't ask, you can guarantee that the opposing counsel will put you under deposition and will ask you that. And then remember that every time there's a deposition, you're in court or any type of legal situation, you actually have to do it under oath. So if you lie, you can go to jail and you can get huge fines. So what do you do in this situation when you're asked on whether or not the accounts and information contained within those reports, or if you have any of those accounts personally, if they're yours, right? So we go over to day 2 of the court, or sorry, part 2 of our day 1. So now you have to tell the truth, because again, if you can't lie, so you either tell the opposing counsel, which is in front of the judge, or you tell the judge that the information there does belong to you. However, parentheses, it cannot be verified as per the section 609. Okay, so the judge asked the opposite counsel, is like, okay, well, what's your statement against that? So the opposite party will simply say, look, we know that this is certified and verified based on what the data furnisher is saying. So what we'll do is we'll get a status correction. I just need some time to do it to get the certification of accuracy. Basically, I'm going to tell the data furnisher to fix it and comply. So the judge agrees, of course, because that is a request. They're trying to fix your report. They're trying to work with you. That's the resolution. End result is you're not asking for money. You're not suing them for money. You're suing them for negative reporting and compliance, which is always the case when you bring up particularly Section 609. So you trap yourself within those confined territories. So the judge says, yeah, sure, modify it and do it within a deadline. So they say, 15, 20 days, whatever. Because it's a rule, it's a decree of the court, they have to do it quickly. So now they make the adjustment. Now what happens? Guess what? Now you have an accurate negative information because the data furnisher essentially complied with the court and the credit reporting agency. Now what do you do? Right? Now what do you do? Okay, so worst case scenario, what happened? Basically, you spent thousands of dollars in a case. First of all, you're crossing your fingers because you knew you had a 50-50 chance going after them anyways. You can't say I had a 100% chance of winning because, again, it's not your fault. Perhaps you're being misinformed. Maybe this is the first time you're landing in my video. You haven't read about the credit reporting settlement agreement. We talked about it a couple of times. But essentially, it's a 50-50 chance of winning. So you spend thousands just to get back to where you are. You got a status correction, which ultimately goes against what you were trying to do in the first place. It's not really changed anything. It made a verified negative item in your report instead of inaccurate. And now you're back to square one, right? Complete U-turn after spending thousands of dollars, right? So let's come back to breaking a misconception. The credit reports, particularly the credit reporting agencies, do they have to contain documents? Wow, that's a big one. But let me break it down for you guys, okay? So there's no rule that states that they have to have documentation. Why? It's because when they have a subscription agreement with the data furnisher, the bureaus are not held liable for inaccuracy past the point of when the items being challenged or disputed from a consumer, and then they send the ACDV to the data furnisher. But at the time, thanks to the credit reporting settlement agreement and that checkbox to certify that the information is accurate, past that point, the credit reporting agency is off the hook. Okay, now documentation, let's talk about that. So anything like documentation, signed contracts, it's basically the transmission of private, sensitive, and confidential information. So that violates the rules of the game, right? They cannot have that because it's private. It's not, government can fine them for that. So, when the credit report, data furnishers keep this information, they have to keep it securely because the credit reporting agencies do on-site visits whenever you're furnishing data, and they will check how the information is being stored, how secure it is, et cetera, et cetera. That's part of pre-approval process of a vendor to report. It's something that they have to do, and you have to comply. Okay, so it's when you're asking the bureaus directly why they don't contain and prove documentation about you, it's basically asking them why they didn't break the law. Okay, why didn't you break the law and have my personal sensitive information on your records? Well, they don't have to, right? First of all, that's a subscription agreement between the data furnisher and the credit reporting agency. So when you ask them why they didn't break the law, they don't have to justify that to you. It's just ridiculous. So do they have to have original signed documentation? Absolutely not. Okay, I want you guys to open a business and try to apply for credit reporting, and you'll see what I'm talking about when it comes to the subscription agreement, some of the rules, regulations. And when you actually sign those documents notarized to send it back to the credit reporting agencies as a vendor. So particularly with the checkbox, with the AUD form where you certified the information is compliant, that can be held in court as a means to basically overthrow every Section 609 and any other legalese that you guys are attempting to fix your credit with. So when you're asking the credit reporting agencies, do you contain signed, documentation, etc.? No, they won't because it's sensitive, confidential, private information, and they will not violate the transmission of that information and go through several different laws like tort law, civil law, criminal law, intent to, misrepresent, FTC, guidelines on privacy policies, guidelines on protecting of sensitive confidential information. We can go in so much into that. We can discuss like hundreds of different laws that would apply just by transmitting private, confidential, sensitive information to the credit reporting agency. Okay, so you got to understand that when you're asking them for this, it's not going to work. Yeah, okay. What works is they get these letters, right, and they will basically contain that information, and they'll try to work with the data furnisher to fix it. Sometimes you get negative items removed because they're under pressure. Like they have a limited time to fix information, like literally 30 days, sometimes less, sometimes more. Depending on if you submitted additional information in between. But essentially, they won't contain signed documentation, stuff like that. The AUD contains that checkbox for accuracy. So, asking otherwise is just you can't go ahead and give them something that they don't have in their process of investigation. So it doesn't work. Okay. So I just wanted to give you guys a breakdown of that. I hope you understand why the Section 609 not the most recommended strategy. And of course, why there are other better ways. Now, what are the better ways? Well, simply, when you go out and you look at your credit report, you analyze it. Right? A lot of people just put all sorts of negative information into a single Section 609 template, and then they basically send it off. And when I say certified and certified mail with return receipts, basically you're telling the judge that you're willing to go ahead and notarize and authenticate yourself in front of the court, and you're willing to work with self-deposing documents. When in fact, when you say that, if these items are, then when challenged, when they ask if these items belong to you, particularly from the opposing counsel or party and the judge, you cannot lie. So the judges know that, they're catching up to it. And that's why the new system, the credit reporting settlement agreement, with the checkbox system, with the AUDs and the ACDVs, with the image attachments, where we discussed that in another video. I'll actually put it, below this video, the link of the description on that video and what you can learn about it. But just keep that in mind. Okay, these are the new rules of how credit reporting is investigated, how new rules of information being shared and exchanged are basically presented, particularly with what are some of the regulations that take effect, and what makes a lot of different dispute templates completely basically useless. Like unless otherwise you find a way to ask them specific questions in a specific way. So with that said, I just hope that you guys got information shared on this video, and you took it to your knowledge so that you can actually make more wise and informed decisions. This is very serious. Of course, when we talk about your credit, it is very serious all the time. So I hope you guys enjoyed this video. If you haven't subscribed to the channel, please don't forget to subscribe, turn that bell notification on. So every time there's a brand new video like this, you'll be first to be notified. It is Friday, so tomorrow we will have our finance talk. And tomorrow I'll give you guys a way in which you can find where to apply for funding once you have your credit squared away. What are some of the recommended strategies for what kind of reports you should have when applying for funding? So you don't have to spend thousands or even hundreds of dollars on paying somebody to teach you where to get credit cards. I mean, that's something you can do on your own. I don't think you should pay for that. So I'm going to go ahead and share everything I know on an institutional level as well as personal level when it comes to personal funding. So look forward to that tomorrow in Finance Talk. It's going to be 1 o'clock Eastern Time and 10 o'clock in the Pacific. I hope to see you guys tomorrow, and I hope that you enjoyed this video. Thank you. This is Ali Taraftar, your guide and mentor. Bye for now.